All right. Well, again, let me introduce myself. I'm Suzanne Callahan, and I'm a CRB field manager in both Jackson and Josephine counties. And I've been a part of CRB I just actually celebrated my 7th year anniversary. So, and I would say, yeah, thanks, Bill, my one fan in the room. I would say that even doing this for 7 years, I still consider myself to be on a learning curve. So I just want to ask you all out there before we get started, by a show of hands, how many people have been a CRB board member for 2 years or less? Wow, quite a few. Okay, and how many have been a CRB board member for, let's say, 5 years or more? Still a fair amount. Okay, very good. And would you agree that even for those of you who are more experienced board members who have been on the board for 5 years or more, you still feel like there's more to learn? And that's why we really come to these conferences, right? So I appreciate your attendance and your willingness to learn. We're going to talk a little bit more in depth about parental progress and how it applies to our CRB findings, giving focus to finding number 6, which is our finding on parental progress. Now, parental progress relates to many of the findings that we make here today. But for time constraints, we're really going to just zero in on finding number 6 on sufficient progress. So again, we're going to talk about timelines and some terminology. If you have questions from the information that I'm presenting, please write it on a note card. And then when we break again to do our case synopsis, I'll collect those and hopefully be able to answer as many as possible as we go along. Okay? Here's the finding. The parents have made sufficient progress to make it possible for the child to return home. It is stated as a fact, but we are asking it as a question. Okay? The finding only applies when the plan is returned to parent. If the plan is not returned to parent, if the concurrent plan has been implemented, we address parental progress later in the review process, and finding number 6, parental progress, is not applicable. It's something you would just skip over entirely, okay? The finding is made separately for each parent. So if we have 5 children and 3 of those children are by different fathers, we need to make a finding on parental progress for the mother and for all 3 fathers. Here's the distinction: compliance versus sufficient progress. For those of you who have been on the board for 2 years or less, you have only been on board since we've made our revisions to the findings. Prior to 2008, the finding used to read, the mother and father are in compliance with the case plan and court orders. We heard from several of our panelists today about that distinction. Are they jumping through hoops? Are they walking the walk, or are they talking the talk? There is a big difference between being court ordered to do drug and alcohol treatment and parenting classes and domestic violence treatment and going to those services A, B, and C and completing those services, but having not internalized the information necessary to make changes to get those children safely returned home. So that is a big distinction. The language that we now use, the parents have made sufficient progress for the child to return home, is in congruence with the language that's used on court orders. So our language now matches court orders, novel idea, and it matches the statute. Sufficient progress does not mean the child can immediately return home. It's determined by parental improvement in the areas necessary for the child to return home. So very important for me to stress, it does not mean the child returns home today, the day of your CRB hearing. It's determined by a sufficient rate of progress. Rate of progress, what does that mean? A few of our panelists talked about this, and Becky Orff talked about rate of progress at permanency hearing timelines. Rate of progress is determined by ASFA timelines. So 12 months from time of jurisdiction in the case, or 14 months from when a child was placed into care. That's the time clock that we're dealing with. Once a child has been in care for 15 of 22 months, law requires that termination petitions are filed unless exceptions are present. And there are 4 exceptions. One of those exceptions is a parent is actively working a plan. So there definitely are grounds for extensions, there are grounds for exceptions. But that is how we are using rate of progress. It's how we're measuring it, is in the eyes of ASFA timelines. So you want to ask, what progress has the parent made to address jurisdictional issues within ASFA timelines? So we first need to find out, where are we at on that ASFA timeline? Are we at the first CRB review? Are we at the second CRB review? Are we on the 4th extension? Has the child been in care for 15 of the last 22 months? These are all things that we need to consider when we're determining rate of progress at the forefront of the case. Basis of jurisdiction. We heard a little bit about this from Lindsay Soto. Basis of jurisdiction needs to be based on the founded allegations. So a parent can only be held accountable for the founded allegations and safety threats at time of removal. So look at the petitions. Look at what was court ordered in this case. What was dismissed? Maybe there were allegations of domestic violence. That allegation was dismissed. That parent cannot be held accountable for those domestic violence issues, only the founded issues. Make note of stipulation for services. So there may be allegations that were founded by the court, parents took a plea, those allegations were dismissed with stipulation, meaning they're still held accountable for the services that pertain to that allegation. Look for amended petitions. As Rebecca Orff discussed earlier, if you're seeing that there are major safety threats present in a case and the basis of jurisdiction had nothing to do with those safety threats, you as a board could ask for a recommendation that the court consider, or that the agency meet with legal consultants with their DOJ and ask for an amended petition. So we have some teeth and some court orders for that parent. So basically, in a nutshell, what I'm saying, the services the parent is held accountable for needs to bear a rational relationship to the basis of jurisdiction. We're going to look at confirmed safety threats. So when the agency goes out and does their initial protective capacity assessment, does their initial removal, what were those safety threats that were present, and how has the parent addressed those particular safety threats? What's in the action agreement? What's in the letter of expectation? What are the court orders? Minimal conditions for return. We'll talk about this some more later in the presentation. But again, the goal is to get these children home with an in-home safety plan as soon as possible. Not that we just keep raising the bar and setting the mark out further and further and further and further. It's how soon can we get these children home safely. And the child's age, needs, vulnerability. We talked about this with our panelist members, that it may be a situation where a child's needs are so great that the child's needs will negate parental progress. So a parent may be completely involved in services, in their treatment, going to family counseling, but that child's needs may be way beyond parental capacity. So again, distinction between compliance and sufficient progress to get that child home. And those are the legal considerations. As far as ASFA, the law requires measurement. So under the definition of the law, every child in substitute care must have a periodic review, an administrative review, and that's either done in court or it's done by an administrative body. And in the state of Oregon, you are the foster care review system. You are that administrative body that's providing these legal reviews, and your reviews are in lieu of a court hearing. So the law requires that when we are considering ASFA, the following must be considered: the safety of the child, the continued need for ongoing placement, which is the last finding we make, and the extent of progress made by the parents. Safety model terminology. I'm not going to go into detail about safety model terminology. For those of you who have been on the boards for a few years, you may already feel saturated with training on safety model language. But what I do want to say, and Linda discussed this, is that this is child welfare's current policy and procedure. It's based on the Oregon safety model, and it gives greater emphasis to the safety concerns identified at time of assessment. So we're looking for behavioral changes. We're taking what was present at time of removal, what were the safety threats identified at time of removal, and then what progress has the parent made to resolve those specific safety threats. It's using this terminology, it's using these assessments as a tool to measure behavioral changes and not just compliance and attendance in services. Again, the goal is to return the children with an in-home safety plan as soon as possible. And then there can be community-based services. Then there can be wraparound services to hopefully enable that to be a successful plan. This is just a diagram or the list, a chart of the 16 identified safety threats. And again, I'm not going to go over this, but I just want you to see that this is the checklist, this is the assessment that child welfare workers use, and DHS can refer back to these safety threats to see if they are still present, maybe they're being partially resolved, maybe new safety threats have come to surface. Other factors to consider. The information itself. You all are receiving your documentation 10 days ahead of time. Maybe you're receiving e-documents. Hopefully you're receiving e-documents, electronic packets. Maybe you're receiving your written materials in the mail. Regardless of how you receive your materials, you should be getting your DHS, what's currently called the 333 case plan. You'll also be receiving the court orders. You should be receiving some collateral input, some treatment reports, some visitation reports, some additional information. Now, the problem may be that information may be 60 days outdated, and a lot can happen in a case within 60 days. A lot could happen in a case in a matter of a week's time, right? So when you're first preparing at home prior to your CRB review, you're going to want to go through all of that case documentation, fill out your prep sheets, however it is that you best prepare for your cases, and identify the gaps. What do you need to ask at time of review? And get your head wrapped around the idea of what are the major safety issues that seem to be present in this family? And when it comes to parental progress, what are the things that I need to zero in on? What were the safety threats? What do I need to ask the parents at time of review? What are the gaps I'm still missing? We need to have an idea about that so when it comes time for the review itself and we have parties present, we're able to get the verbal input at time of review. Timeline. This is the biggie. Again, consider the length of time the child has been in care. What was court ordered? Where are we at with that ASFA timeline? The timeliness of the services provided. So this timeliness goes to, as Attorney Soto was discussing, not only the timeliness about when the parent actually engaged and followed through, but what has the agency offered to this family? Parental progress is very much tied to reasonable efforts and what the agency has provided to that family. So what was court ordered? When was it provided by the agency? And then how quickly did that parent engage? That will give you a measure of motivation and follow through. Was a parent only recently located? Was jurisdiction only recently obtained on a parent? Have we had an absent parent who has only recently come into the picture? Then you're going to want to consider not just the timeline itself about where we are on the ASFA timeline, but where does that parent fit into this timeline? Internalization. And this again is the distinction between compliance and sufficient progress. This is a really difficult thing to measure. How do you really demonstrate if a parent is internalizing those behaviors necessary for change? So we want to not just look at attendance and did they go to drug and alcohol groups? Are they going to their NA meetings? But as Gary Hurd said, what are they really doing in the community? What are you hearing back from community members? What does the caseworker see when they go into that parent's home? Who are the support people in the parent's life? Is the parent demonstrating sincere reform? Are they demonstrating motivation? Are those behaviors observable, or are they just going and sitting in services and attending services? It's a difficult thing to measure. We want level of benefit. Feedback. This is not just between the caseworker and the parent. It's not a single relationship. Casework is done with all parties involved. So just as in the drug and alcohol model that we heard about earlier, there's monthly treatment team meetings. We want the caseworker to have collateral input from all treatment providers that are working with that family. We want to hear from the mental health therapist. We want to hear from the domestic violence educator. We want to hear from anybody working with that family, with those parents, to really be able to determine, is that parent making any changes? And minimal standards, not our standards, not what we deem to be an ideal parent. It's minimal standards. Has the parent met the minimum threshold to get these children home? And that is really difficult for a lot of board members. It's difficult for me. So it cannot be a comparison of, Sally is doing so well in her foster home. She has horseback riding lessons. She's learning to play the piano. She has her own bedroom. They're looking at getting her some math tutoring. It can't be a comparison of what's currently being provided for those children and what that parent may be able to provide. That parent may be able to provide a studio apartment. They may not have employment, but they have met the minimal safety threshold to get those children home, and that's what we have to measure. We can't keep setting the bar further and further and further back. Specific criteria. Okay, now I'm going to go into a little more meatier detail. Some of this we've already covered. What was court ordered of that parent? Specifically, what was court ordered of that parent? In some counties, courts make specific court orders, and in other counties, the court will just order that a parent comply with an action agreement or a letter of expectation. But again, you need to have a very clear picture of what was court ordered, what are the expectations, because in order to judge a parent on progress, we need to know what the expectations are, so we have specific criteria to inform our decisions. We need to know what was required at jurisdiction, then determine how the parent has addressed those jurisdictional issues. Specifically, what have they done on each of those jurisdictional issues? So as Attorney Soto talked about, if it was a lack of relationship with a child, what's the frequency of attendance? What are they doing to reestablish a relationship with a child? If it was domestic violence, well, what have they done to change or to separate themselves from that relationship that was unsafe? What have they done in their domestic violence treatment program? Are they working with an advocate? Do they have a restraining order? You're looking for measurable changes. And factual proof from community partners. Not just what the parent is telling us, but what are the treatment providers telling us? What does the documentation say? And if you don't have the documentation at your time of review, you're going to want to ask specifics of the treatment providers who are present. Are those changes in parents' behaviors observable? So again, we talked about this. What are they showing in the community? How has their lifestyle changed? How has their motivation changed? How has the relationship with their children changed? Their relationship with their caseworker changed? What are the remaining barriers? You may be at your 6-month mark. Parent may be looking like they're making some progress. So identify then what is left relating to the safety threats present at time of removal. What is left? What are the remaining barriers that keep this child from going home with an in-home plan? not what else needs to be done for this all to be wrapped up and sealed in a happy little bow, DHS to dismiss wardship. What else needs to be done immediately to get those kids home safely with an in-home plan? And finally, at this current rate of progress, is it likely that safety issues can be adequately resolved within a reasonable period of time? And reasonable is in the eyes of that child. That may be different for an infant than it is for a 17-year-old. So if I'm on this timeline and I'm at the 6-month mark and I've got about 6 more months to go before that permanency hearing, and the parent is looking to be somewhat compliant at this current rate of progress as they're proceeding down the timeline, by the time we get to that permanency hearing, approximately 12 months into the case, is it looking likely that we could achieve a reunification plan? So we're not just looking at what has occurred the previous 6 months, but we're looking at an assessment of what could occur in the next 6 months if you're at an initial review. Questioning strategies. You know, I was saying earlier this morning that, I don't know, did anybody go to the verbal judo workshop yesterday? Yeah, it was great. It was really great. And I think we could have an entire workshop on questioning strategies, on effective communication, on effective board demeanor, about how we ask questions, because it is vitally important how we ask questions to the parties across the table from us. Because how we ask it, not just what we ask, but how we ask, is going to determine what kind of information that we're going to get. So Dan Garris said yesterday that 93% of our effectiveness lies in our delivery state. We need to address all parties present. We need to address not just the caseworker. We're not asking all of the questions to the caseworker, not asking all the questions to the parents. We may not even have the parents present, but we still have to make that finding. We may only have one parent present, and they may be doing a really good job of pulling on your heartstrings and telling you the right things, and you're going to want to make a yes. And then it's really easy to dismiss the parent who's not there, because, oh, well, we see on paper, he's not doing much. You need to make a fair assessment of the parents who are there and who are not there, individual of each other. We need to talk to the attorneys present. We obviously need to talk to service providers if they're present. Hopefully they are present. Hopefully the DHS caseworker has included them on the address sheet and they've actually received notification and are able to come. If they're not present, we're going to have to rely on either written documentation or verbal documentation from other parties. We want to speak with the children and the teens themselves if they're present. Now, granted, we need to do this in a sensitive way, but they may have the best information. They know their parents. Here's a tip. Pay close attention to who is present, who is in attendance. So when you read the opening statement, we all go around the room and introduce ourselves. Make note about who is present. The lady in green at the end is mom's sponsor. This gentleman right here, that's dad's attorney. And we want to write down their names, not just their role, not just mom's sponsor, mom's advocate, mom's drug and alcohol counselor, dad's attorney. We want to make note of their names. So when you get to parental progress and you're thinking about who in this room of people, and sometimes it can be overwhelming. I mean, sometimes, you know, you may just have 2 people present, and boy, sometimes you could have 30 people present, and you may have every neighbor and cousin and lots of people. You don't need to address everybody in the room, but you need to have a good idea of those legal and interested parties who you have to address. So developing questions. Again, I feel like we could do an entire workshop on developing questions. But one thing that Dan Garris said yesterday in the workshop on verbal judo is be careful with how we ask our questions to avoid defensiveness in other people. Now, we are already setting ourselves up for a little bit of a power struggle. You are the administrative body. There's the field manager, review specialist that's doing the facilitation behind the computer. We look very official. And then we have the parties present. The attorneys and the caseworkers, they're old pros of this, okay? They've been coming to lots of CRB reviews. For a parent, that's a high anxiety state. A parent doesn't know the juvenile law. A parent doesn't know really what it is that we're looking for. What is the purpose of the CRB review? You may be reading your opening statement and it may be going right over their head. So we want to be able to articulate to the parent what it is that we're doing here today. And what does this finding mean and how are we measuring it? So the quality of your questions affects the quality of information that we're going to gather. And we want to be sensitive to avoid defensiveness. So we don't want to ask really open-ended questions. Mom, what do you want to tell me? Dad, how's it going? That's essentially just tossing over control of the review to that parent. And you may not get any valid information that you need to make that finding. So you want to ask specific questions to obtain information needed. If you want to know something really straightforward and get a succinct answer, you're going to want to ask closed-ended questions like, what was the result of your last UA? Something really straightforward. What's your clean and sober date? If you want more detailed information, you're going to want to ask more open-ended questions. If you're trying to get some detail, if you're really trying to measure progress, you might want to say, Ms. Jones, what's your understanding of Elizabeth's medical diagnosis? Are you able to go to her medical appointments with her? What's your relationship like with her doctor? You know, is there anything else that you feel like you need that would be of benefit for you to have a better understanding of your daughter's medical condition? You want to ask more specific information. Or what's your current involvement in drug and alcohol treatment? It's more of an open-ended question. It's going to take that parent to be able to think about giving you a more comprehensive answer. Here's a big thing. Prioritize your questions, okay? We have a really serious case. It involves physical abuse by mom's partner, domestic violence, methamphetamine use, you name it, right? All of the really serious issues. And then the board will say, do you have a job? Prioritize your questions. So deal with the big issues first. And I would say this is true when we're on a finding about a child's needs too. You have a child that has major behavioral issues, major mental health issues. We're going to want to address those major big ticket items first. Prioritize them. We want to find out about involvement in the court-ordered services. We want to follow up about specifics first. Then all the little details that hopefully you are not just asking because you're curious. You're asking because you really do need this information to make your finding. Not the I'd like to know, but the I need to knows. But prioritize your questions in order of importance. And direct your question to the most appropriate party. If you have the drug and alcohol treatment provider present, you're going to want to ask the drug and alcohol treatment provider, what is Mr. Jones' involvement in services? What is his progress? How do you rate his progress? How long has he been part of the program? You're going to want to ask the drug and alcohol treatment provider specifically. So here's just some ideas of questions. And again, all of these documents and PowerPoint presentations, even from the panelists, will be on the website for you to refer to later. But just some examples of some questions that you could actually ask of the parent. Common ones might be, what is your clean date and what healthy supports have you established? Or Terrence and Talisa have previously been in care due to concerns of neglect. What changes have you made since the children's reentry into care? Again, you're soliciting a greater amount of detail from these parents. What have you learned from working with the parenting coach? What's the status of your criminal charges? What's your current living situation? That's a big one. Safety of the living situation. What are the barriers to your participation in services? So if a parent hasn't been able to access a particular service, what is the barrier that's preventing them from doing that? And again, that goes to motivation. And also, it may be going to the agency's failure to provide that service. And you need to know that. Because again, a parent's motivation to complete services can only go so far if they haven't been afforded the opportunity to do that. And you could ask a parent, are there any additional services that you feel would be of benefit? Are there any additional services that you feel like the agency should offer you? Questions to other parties, and again, these are just a few examples. I mean, the range is broad, but you could ask the agency specifically about what is their position with regard to parental progress. What additional expectations do you have, Mr. Caseworker, of the parent before reunification can take place? What's the level of contact you have with the parent? You could ask about the visitation plan. You could ask one of the attorneys, what's your client's position about proposed reunification plan? Again, it depends who you have in the room about how you're going to formulate questions. And you don't know that in advance. So you really just sort of have to think on your feet about who is best to ask this question of and what information do I really need to get. When it comes to making the finding, again, we make this finding separately for each parent. You need to ask, is the parent making sufficient progress toward reunification? So again, at the current rate of participation in services, is it possible that reunification could occur within a reasonable timeline? We need to briefly summarize the rationale for the yes and no. So if we just have had a 20-minute discussion on this, we don't need to reiterate everything that was just said. But we do need to briefly summarize, especially if you make a no. Why are you making that no? Making the no because behavioral changes haven't been made. You're making the no because mom's still in a relationship with the abuser. You're making a no because even though Ms. Jones has participated in family therapy and is attending monthly treatment team meetings, she does not have the capacity to meet Elizabeth's medical condition. And we need to make recommendations that address any no findings. So it's all right to make specific recommendations to a parent. When you get to the end of the review and a parent is not actively complying with the specific requirement or a specific service, make a recommendation for that Mr. Jones is to call on track and schedule a drug and alcohol assessment and enroll in treatment. Or the mother is to work with her DHS caseworker to resolve housing barriers. Okay, just a note about board demeanor again. Be aware of your own triggers and your own emotional state. When parents are coming into a review process, they may be fully engaged by that point. They may be still very defensive and very angry. And I don't care how big of a jerk dad is, we still have to conduct a professional review. So the way we ask our questions sets the tone. Are you showing a reaction? Sometimes, I don't know about, I'm assuming it happens for everyone, when you're reading your case materials and you're preparing for a case, sometimes the details of that just give you this visceral response. And you have to process those emotions ahead of time. And when you meet with your board and you're discussing your cases at the beginning of the day, you're talking to your fellow board members, you're talking to your field staff about that, you're processing those emotions. Yes, you're getting your game face on, you're getting ready for how you're going to ask questions and how you're going to conduct that review, but you're also processing whatever your triggers are then. And that's a safe place to do it. But when all of those parties come in, that needs to go away. Game face is on, you need to conduct a professional review. So even though you're sitting across the table in very close proximity from the person who physically abused their 2-year-old child, you have to be just as professional, just as courteous to that person as you would to any other party in that room. So you're conducting a legal review. You're not facilitating a family decision meeting. Our purpose is to make a set of legal findings. And yes, the CRB forum is more informal than a court hearing. Yes, we have more time to prepare for these cases ahead of time. Yes, we have more time to dedicate to each individual case review. But we are not there to facilitate a family decision meeting and to work out and to plan every detail in that case. So avoid giving, yes, you can make recommendations, and yes, you might have great ideas for how something can be resolved, and that is your citizen input, and that's very valid. But going above and beyond that, avoid trying to problem solve every detail. Avoid lecturing and counseling and storytelling about your own personal experiences or scolding that parent. You may be doing that directly or indirectly just in how you ask your question and what you say. I said this earlier, address the parties by their name and not their role. You don't want to say, now I want to hear from you, Mom. How's it going? What services are you doing? Or I'd like to hear from the dad's attorney. Address them by their name and their role. That's a more professional review. And be very conscious of the time that you have. This is true for any of your findings. We may have 40 minutes for a new review. And parental progress can take up a lot of that time. So can the needs of the child. But we don't want to get so far sidetracked and so bogged down on the details and on this particular finding that we're not covering all of our other legal findings. So just be careful that we're staying on track and not spending too much time talking either about this particular finding or talking to one person at the same time. All right. When the plan is not returned to parent. Again, the finding number 6, as it relates to sufficient progress, is only made when the plan is returned to parent. So it may be your first review, it may be your second review, we may be on an extension, and it may still be returned to parent. Whatever the court-ordered plan, that's what we go off of as a court-ordered plan. If the court-ordered plan is still returned to parent, we make finding number 6. If it's not returned to parent, we want to address parental progress. So just as the agency is not relieved of providing services to a parent throughout the life of any case, we have to consider parental progress in every review that we do. It comes into play when we're talking about the permanency hierarchy. And the highest form of permanency for a child is return to parent. The next being adoption, guardianship, and then we have our applique plans. So we would still want to ask parties the questions. We want to ask for any updates of that parent. And then under finding number 9, when we're dealing with the permanency hierarchy, we can make mention of why it's not appropriate for reunification to take place if reunification is no longer the goal. When it is returned to parent, we still want to address what are the remaining barriers that keep these children from going home. And your findings should be congruent. If you said yes, that you have parents making sufficient progress under finding number 6, and we get down to finding number 9, and it's, is the permanency plan the most appropriate plan? And the board says no. No, we should move immediately to termination. Well, that doesn't seem congruent if you're finding that a parent is making sufficient progress. So we need to take into account what are the remaining barriers, what are the legal circumstances of this case, where are we at with the timeline. All right, practice, here we go. This case involves Victor, an 11-year-old special needs child who is currently receiving community-based wraparound services due to his behavioral and emotional needs. He's been in the same foster home since June of 2010. He disrupted from his first foster home due to aggressive behaviors. Jurisdiction was based on the mother's substance abuse issues, the mother's history of mental health problems, the father's substance abuse issues, and the father's involvement in criminal activities. The mother has completed outpatient drug and alcohol treatment and is currently involved in parenting classes and in individual mental health counseling. Treatment reports are positive as to her attendance and her level of progress in services. She has physical custody of her older daughter. The mother is anxious to have Victor return home. Visitation reports indicate the mother is attending visits regularly, but she has difficulty managing Victor's behaviors without the support of the visitation staff, and the relationship between Victor and his mother remains strained. Family counseling sessions between Victor and his mother have not been productive. Father has repeatedly been incarcerated on drug-related probation violations since Victor's entry, but he recently enrolled in drug and alcohol treatment through community corrections. This is your second CRB review. So given this scenario, I'm going to ask, do we have a microphone, Sam? Sam's going to be coming around with a microphone. Given this scenario, what would be your finding on Dad? Let's start with Dad. Volunteers? Okay, I just have thumbs down. I can hear some no's. Anybody want to explain?
So you're saying no. Why would you, on what basis would you?
So even though Dad has started alcohol and drug treatment, we're 9 months in to this plan, and that's not soon enough to be sufficient progress for him to have addressed his problems.
So because of the timeline, because the child's been in care since June, and because we're already on a second review, so we're getting close to the 12-month mark. Okay, does everybody agree with the no? Okay, pretty straightforward on Dad. What about on Mom? What would your finding be? And why? I see some head shakings like, oh.
Well, I think what you said earlier,
There's a mic.
Oh, I'm sorry. I think what you said earlier, she's compliant, but it doesn't mean the child goes home today. And so she's doing what she needs to do, and it looks like she's actively doing what she needs to do. But they still need to have more help to make it safe for the child to go home. So yes, I would say she's being compliant, but the child can't go home yet.
Okay, so would you say she's making sufficient progress?
Yes.
She is making progress?
She is making progress.
Okay. I see some other comments, some other hands.
I just wanted to add, because I agree, I do think she's making sufficient progress. I'm not sure that she's not capable of having the child home now. It says the relationship strained. Obviously, they need some mentoring, some support. It sounds like she's doing okay with her daughter. So what are the specific issues? That's what I would want to know. What are the specific issues that are going on with the son that make it difficult? And could she have him at home and get the support she needs? Because it doesn't sound like a safety issue. It sounds like a relationship issue.
Relationship issue, again, it's the needs of the child. Any additional comments?
And we heard a no, so I'd like to go to somebody whose position is no.
I said no originally, but I guess I need more information. You need to talk. Oh, sorry. I hope everybody can hear me. I think you need to talk to the mom. You need more information from the mom. Yes, she's completed all of her services, but you need to see how is she engaging with it. How is she going to be able to handle Victor, who appears to be a difficult child and has his own issues. So I don't think there's enough information without talking to the mom to make this decision. That would be I'd have to get more information.
Okay. Scenario is too brief for you. Okay, let's take a comment up here.
This is one that I call yes, but.
Uh-huh.
So I think we say yes, but then there has to be a series of recommendations directly to the mom about what kinds of things have to happen. And if we're looking at a year out, we only have like 3 months before we meet our ASFA deadline, unless there's an extension of some kind.
Unless there's an extension.
Yeah. So we won't see this case again unless there's an extension. I mean, we'll see it again, but...
Well, we would see it again for the life of the case. So because it's a second review, we can assume that 12 months or close to 12 months has passed. And mom is demonstrating progress. She's getting favorable reports. And obviously she's making some progress because she has her older daughter in her care, right? But this could be a situation in which Victor's needs, his behaviors may be beyond that of mom's capacity at this time. And that his needs may negate mom's progress. But this might be a situation where the board may endorse an extension. And it may be possible that within an extension, because of his age, if there were some additional therapeutic services, that we could reach that level to where we could bring mom and son together. So again, just want to get you thinking about the whys, not too concerned with what actually, whether yes or no is the right answer. Okay, let's try this one. This case involves Cassandra and Colton, 4-year-old twins. The mother has had her parental rights terminated to 3 older children. The twins were brought into care due to the mother's substance abuse issues, domestic violence, and the mother's inability to protect the children from unsafe situations. Jurisdiction against the father was established due to the father's history of alcohol use, lack of custody, and failure to maintain a relationship. The father is now visiting regularly. He previously completed alcohol diversion classes related to his DUII. He is in support of the children remaining in the home of the maternal aunt, where their children's older half-siblings also reside. He doesn't feel he could be a primary custodial resource for the twins due to his employment as a long-haul truck driver. The mother has been in 2 treatment facilities since the children's entry into care. She is attending NA meetings and states that she's been clean for 63 days. She's currently at the women's shelter. This is your first CRB review. Given this scenario, albeit brief, what would your finding be on mom?
No. Okay, so raise your hand so I can come to you.
Actually, I would say yes for the mom. Conditionally, she's been in 2 treatment facilities. We really don't know whether she was kicked out of one or both. I'd like to know that. But I think for the first review, given her history, 63 days clean is pretty impressive. And so I think I would say yes with some, and after asking some questions.
But yes, that it could be possible for reunification to occur, because we're only at the 6-month mark. Okay. Hear from other folks?
So the question arises, is she finally getting it after losing 3 kids?
Yeah.
And the information we have is quite limited, but from the information we'd had, I would say yes, but it's very, very important that the rationale go in there, the concerns, the red flags that the board may have. It's a yes, but.
Okay, well, I have some head shaking saying, nope, I disagree.
There's no collaborating evidence that she is clean, just her report that she's clean. So without anybody else backing that up, I don't think we could take that as sufficient progress.
Okay. We have another go ahead.
One of the bases of jurisdiction for the mother is domestic violence.
Right.
And I don't see that addressed in any way there. So, I don't know whether she was so messed up on drugs that she just couldn't reasonably start that training, or whether DHS has been slow to provide it. I'd be reluctant to give her a yes.
She's in the shelter. Okay, another comment up here. I can repeat. There's no reference to visitation? To visitation with the children. So it's a situation where mom has a prior history. She's got a prior history of terminations. She's only maybe made some real recent progress. I heard a comment that 63 days, given her history, is pretty good. So we need to take that into consideration. Maybe you might get the sense that she's shopping for services because she has been through different treatment facilities. So what about the father? What's your finding be on the father in this case? So hands and or for comments? So the allegations are alcohol use, lack of custody, failure to maintain a relationship. So what progress has he made to address those jurisdictional issues?
The dad has been visiting with the other siblings at the aunt's house. This is an opportunity for the children to have contact with their other siblings. Sounds like dad is just getting started in treatment programs. And I'd like to ask more questions of the dad to see what steps he's taking to try to have more contact with his kids.
So you want to ask about visitation. Other comments?
He doesn't want custody.
Okay. So I'm seeing, he doesn't want custody, right? He's saying he doesn't want custody. So what he's saying is he doesn't want primary custody. He's in agreement with the current relative placement at this time because of his employment. But would that change if he were to change his mind? If that comment wasn't in there, if he were to change his mind and say, I would want custody, or my employment's not a barrier? Yeah. I mean, the basis of jurisdiction is alcohol use, lack of custody, and failure to maintain a relationship. He's visiting, he's done his drug and alcohol, and although the custody issue is saying he doesn't want to be a primary custodial resource, it doesn't mean he doesn't want to be a co-parent. Right. Okay. We're going to work on a case synopsis together as a group. If there are any questions pertaining to the CRB findings or based on this short presentation that I gave, if you want to write it on a note card, when we come back and debrief as a group, I will address any of those questions then, okay? I'm not sure if we're going to have...
I'm not sure that we have enough copies for everybody, but please share the table.
We weren't expecting this to be such full capacity.
Looking for volunteers to go away?
No. Sam's got more than I do here. I need a couple more. So we're going to take about 15 minutes in small groups to read through this case synopsis, discuss it. What kinds of questions might you have for the parties that are present at this review? And then just sort of begin to think about what your rationale might be for a yes or no finding. So we'll take about 15 minutes. Okay, if I could get your attention back here at the front of the room, we will debrief this as a large group. I hear a lot of good discussion going on, and I really hate to cut it off, but we have to be out of here promptly in time for lunch. It's very important. So, looking at this case synopsis, and yes, there's a lot of complicated issues in here, and those were given to you on purpose. Because, well, we deal with some pretty complex cases, and it feels like the complexity of the cases is getting even worse, right? So it's not easy. It's not cut and dry. There are often many factors to consider. We've got multiple parents and multiple safety issues and delayed basis of jurisdiction and timelines that seem to be skewed and children's needs being very, very different. It's complex and it's really difficult to tease out. So looking at this case synopsis, what were the safety issues or jurisdictional issues on the mother? And Sam's got the mic, so let's be sure that if you have a comment that we use the mic.
For the mother, it was simply substance abuse issues that, for her parenting, threatened her ability to parent.
Mm-hmm.
But
So
substance abuse
primarily.
only.
Mm-hmm.
Well, that's all it says.
Okay. And how long have these children been in care?
15 months.
Okay, I'm hearing some differencing. I hear 15 months, I hear 6 months. Okay. They have been in substitute care for 6 months. And this is a first CRB review. But how long have the parents or family been receiving services? Off and on since 08, 09, but DHS has been providing services to the family since 2009. There had been some prior referrals previous to that timeline. So again, we're looking at a situation where, although the children have only been in care for 6 months, this is a family that has a lot of case history, and that case history is a factor when determining progress. So what specifically has the mother done to address the safety threats? What's mom done? Let's start with her. Again, it takes some discussion. Well, what has she done? Anybody want to be vocal?
I find 2 times a month to a DNA treatment is not adequate. I've discovered that addicts sometimes go to 2 meetings a day.
It's 2 times per week. She's going to support groups 2 times a week.
And that's not sufficient for her, considering her history.
Okay. What else is she doing as far as her recovery, though? She's doing treatment. She's doing a dual diagnosis group, right?
And she's going to something every day.
She's going to something every day. Okay, and the basis of jurisdiction was substance abuse. So do you feel like the mother is making some progress toward resolving her substance abuse issues? Yes. Okay. So looking at the parties that we have present, we have the caseworker, the foster parent, the mother herself. We have the mother's drug and alcohol counselor, the father's attorney, and the child's therapist. What are some questions that you might ask of those parties? So looking at this case history, reading this documentation, what kinds of questions would you ask if you had the mother and her drug and alcohol provider sitting across the table from you?
Is an issue here. The evaluator indicated prognosis is poor without Ms. Bogle's willingness to embrace recovery. So there's an issue of has she embraced recovery or not? So that would be one of the questions I would ask the DNA treatment person. And
you would want to ask the drug and alcohol counselor if you feel like she's fully embraced recovery?
Right. Right. Because she is attending, but that doesn't mean that she is actually believes, that she has an issue and that she has a lot of work to do.
And that was when she first did her drug and alcohol assessment, is that correct? When she re-enrolled in her treatment, the evaluator indicated that prognosis was poor without her willingness to embrace recovery.
That was 4 months ago.
Right. So now she's been in there for 4 months, and her counselor is giving you a current report that she is taking greater accountability. Other hands.
I would do a variation of that question about the AA. I'd ask her which step she is at in AA.
What step are you on?
What step are you on?
Yep. Yeah. Do you have a sponsor? How often are you attending groups? That would have been your question. Sorry to steal your thunder there.
I would also ask, what is her barrier for not getting a sponsor? Is she against getting a sponsor? So that would be kind of the question I would ask.
So it's a very true testament at time of review or in court when you ask a parent about their clean date and they say, about 6 weeks. And when they say it was March 31st. Any other questions that you would ask of the parties, mom and or her attorney, to determine her progress?
She's in a dual diagnosis treatment program. What are they doing about mental health services?
so you would like to ask more detailed questions about what they're doing on the mental health treatment aspect of that. And that is what a dual diagnosis group is, for those of you who aren't aware of that. Dual diagnosis group treats comorbid disorders, so drug and alcohol and mental health conditions at the same time.
My question is, why did she, why did she get rid of the domestic violence or the restraining order against her husband? Because that has something to do with the child to safely go back. Or the
How would you
to safely
phrase that?
Yeah, what was your, well, yeah, I think it would just be flat out, you know, why did you remove the restraining order against your husband? Or why was the restraining order removed? Or why did you recoup it?
Or could you help me understand why you requested the restraining order against your husband to be dismissed?
Right, because that was a factor in
right.
the safety of the children.
Mm-hmm.
And if it was a cultural issue, would she know?
If it was a cultural issue, you know, and that's another layer to this. How would this scenario change if the father was not a natural citizen, or if English was not his first language? It would change. It would change. It would change the finding. It might change the board's rationale. We don't know that. So you're having your own. Yes, we're having our own little conversation up here. So how would you make the finding on the mother in this case? Yes.
Before I could make any finding with either parent, in addition to the services that are providing, the main question in my mind is, how do these parents relate to their children? Do their children feel safe in their care?
Right. So, and I'm glad you brought that up, because in this scenario that was given to you, we have 3 children, and one of the children is saying, I don't want to go home to mom. I want to live with dad. And the relationship between mom and that child is still strained. And the child's needs, the child's preferences need to be taken into consideration. So we can't split a finding for different children, but we certainly can make note of that. Anything else on the parent or the mother? Okay, so just sort of by a show of hands, would folks say yes on mom?
No.
Okay. Who would say no on mom?
I don't have enough information.
Well, again, that's the trouble with these exercises. They're limited. I want to hear from a few folks that would say a strong no on mom, and why.
Mom has been very slow to engage, and she's doing better recently. But it's not clear to me that she's made sufficient progress with her alcohol problem. And also, while I've got the microphone, it's interesting to me that she's apparently been diagnosed with some kind of a mental health issue. We don't really know what it is. Is she depressed? Is she bipolar? There's no basis of jurisdiction which relates to that.
Correct. There is no basis of jurisdiction that relates to that. Her drug and alcohol evaluator had recommended a dual diagnosis group, which she is doing. But you would say no at the 6-month mark because you feel like her rate of progress is not sufficient?
Right. I would commend her for what she's doing, but I would say no.
So you don't think it would be possible?
I'd commend her for taking the correct steps to get to where she needs to be, but she's not there yet. That's what I'm saying.
But again, now, and that's the difficult thing in this scenario, is that the children have only been in substitute care for 6 months. So they have not been in substitute care since basic jurisdiction. They've not been in substitute care for 15 months. But the case history is much older than that. And that's what you say would be the problem with on mom? Okay. Just want to get you thinking about that. Again, no right or wrong, but the finding does not mean this child can go home today. It is within the current timeline. And the next event, the next judicial event in this case, is a review hearing that's coming up in 2 months. Permanency review hearing on June the 12th. And then at that point in time, the court will evaluate progress and determine if whether another extension is warranted.
So just for clarity's sake.
Uh-huh.
What I'm hearing you say is that, okay, I hate these things. So, just for clarity's sake, what I want to understand is, so even though they've been in-home care, we've had DH services engagement for a significant period of time, because we're looking at the timeline, I can't even say it. They're only in care for 6 months, so we're really only able to look at it from that 6-month window. And you kind of ignore what's going on.
No, in this situation, no.
And I guess that's where I'm struggling.
You want to look at the fact that petitions were filed back in 2009. The court established jurisdiction back in 2009. There has been regular court hearings since such date, and DHS has provided services since such date. That is something you have to look at. You know, it seems like more and more, especially with the implementation of the Oregon safety model, what we're seeing is delayed onset of cases. We are seeing attempted in-home safety plans, where the agency is trying, if at all possible, to leave children in the home with in-home safety plans. And then when those in-home plans fail, those children are coming into substitute care. So that scenario seems to be happening more and more. You do want to look at when were the petitions initially filed. We might have had petitions filed in this case for quite some time, and DHS involvement, but the children haven't come into substitute care, you know, until recently.
But that wasn't the question. So what I'm saying then is, okay, we're looking at it from a, okay, so we're saying, regardless that they have had in-home care services, et cetera, right? And you're looking at all of that information, but because it's the first review and you're looking at it from when the children are in care and it's for that 6 months, you can't, for what I'm seeing is that you can't take into account what might have failed while they're in a home care.
You can, and you should.
So what you're saying is, in this case, the mom isn't making sufficient progress because you need to count in that full 1.5 years of stuff. And I'm trying to understand, how does that work? Because that's not based upon what we've heard from what our timeline is of when the child actually comes into care.
You're looking at both. What I'm saying is that you can't dismiss the case history and the fact that the agency has provided services to this family since 2009. But you also are looking at time in sub-care and substitute care. So you're looking at both, but no, you shouldn't discount case history.
And we can argue with our field manager on that basis.
Well, I think, you know, case history is very important. We are measuring rate of progress within given timelines. So if you have a family that has prior terminations, prior case history, and they've only recently made progress, maybe their success rate is going to be much less than a parent who is just now receiving services and fully compliant and fully engaged in the case plan. So don't discount case history, but do look at where we sit on the legal timeline of the case. That's all.
And that's the real question. If they're 6 months now into care, but they've already had 2 extensions. They had an extension prior to
they have.
Care.
So
which timeline, I mean, are we now going to consider a 3rd extension? Or have we dropped back to a whole new calendar that's now only 6 months?
The time clock is ticking. The time clock is ticking for when they're in sub-care. And ASFA timeline looks at 12 months from base of jurisdiction or 14 months from entry into sub-care. And that's the complicating factor in this case. Or. Before I want to switch gears here because I know we're running short on time. So, comment.
I just want to say
my understanding that if we have a legal CRB board meeting and we disagree with our staff person, we make the call.
We're going to get a round of applause on that. Okay, your staff person is there to inform you and to interject about policy and law. And we're the ones that give that information to you and give you those parameters. What I want to say to wrap this up, and I will be brief to get you out of here, is that this ultimately is your finding to make. It is not my finding to make. It is not Dad's attorney's finding to make. It is not the mom arguing with you. It is your finding to make. But just be careful that you are clearly articulating the rationale for your finding. So, to sum it all up, it's important that we're just, when you get ready to make that finding and you're on the brink of doing so, that you're looking at current rate of progress within whatever timeline we're on. And at that current rate of progress, is it possible as we go along to get those children home within a safe amount of time with an in-home plan? And what information are you basing that off of? Do you have collateral information? Does the agency have collateral information? Okay. There was one question here. I do just want to say, when you have multiple, this one says, is there a mom and 3 different fathers? How do you make findings on each father, even though the kids are only going home to one parent? You need to make a finding on every single parent, even if that parent is not going to be the custodial parent. Okay? And document. Just document and explain your rationale and make that transparent to the parent sitting across the table from you, because they're going to shut down. They're going to get defensive when you say, no, I haven't done what I need to do, because they feel like they are. So thank you very much. I know we had to wrap up quickly here at the end, but I'll get you out in time to check out of your rooms and for lunch. Thank you very much.